Hello, good afternoon, viewers. You are with Adil Farooq, watching Legal Lounge with Adil Farooq, and thank you very much for watching my logs and my small videos on different issues. Today, I'm coming with a very unique but important aspect in a real estate transaction, which all the buyers and sellers should aware of when they are dealing with a real estate transaction. When they are buying or selling a property, they should aware of this fact, and they should take care of this thing, whether their lawyer or any professional inform them of during this process or not. Before I start, as a standard disclaimer, this information session is for information purposes only. Please don't apply this information, or don't take it as a legal opinion. If you have any concern or question about your special circumstances, feel free to contact us or with your legal professional, who will help you to understand the consequences and the nature of your transaction. So to start with, I have to give you some good or some bad examples, and for your information purposes only. Whenever you are buying or selling a house, you as a buyer or seller, you have to take care of the existing utilities on the house, which means then if you are buying or selling a freehold property, which may include your townhouse, which is freehold, semi-detached or detached properties, you always have at least three types of utilities you are using in the house. One is your gas, one is your electricity, and one is your water. If you are hooked up with the municipal water, if you have your own source of water, that the last water thing does not apply to you. So when you are buying a property, you should contact with all of the utility departments in your area. I will suggest a couple of days before your date of closing, and inform them that this is my date of closing. On that specific date, I will be the owner of the property. What they will do, they will take readings of all of your utilities on the date of closing in the morning time, and they will set up your account effective from the morning of the date of closing, and they will send the invoice of their existing charges to the previous owner at their address, and they should be liable to pay for those expenses. And that's also important for you to protect yourself from any extra charges or anything which is not related to you. And from the seller's point of view, I always advise my seller's client to call the utilities and tell them the date of closing of your sale, and request them to cancel your account and give them your account number where they can send your invoices for payment. If you fail to do that as a seller, if you fail to do that, the account will continue running under your name, and maybe eventually you will be liable to pay for the utilities which the buyer has used, and if they fail to call them. And if the buyer failed to call them but the seller already called the utilities, the utility companies will disconnect their utilities effective from the date of closing, and sometimes they gave you a couple of days to call them. If you fail as a buyer, if you fail to call them, they will disconnect your utilities, and you will have to pay for the reconnection fee to the utility department, and that will of course create a problem for you. What happened if one day you come out and the house and there's no light, or there's no water, there's no gas? You will be panic, and if you don't have a time to connect with them, they will not connect back the utilities, and they can always charge you for reconnecting of any utilities if you fail to set up your account. Likewise, for the property taxes, if you are paying your property taxes on monthly basis, or if you are paying automatic payment, let's say you are doing automatic payment from your bank account, that's your responsibility to send a note or call to the utility department to tell them that your date of closing, and not the utility department, I'm sorry, to the tax department, because the tax department is responsible to deal with your property taxes. So they usually take 2 to 3 weeks to cancel your pre-auth. So when you are selling a house, I will suggest at least call them 2 to 3 weeks before the date of selling, so they will stop your pre-auth, and that you have to inform to your lawyer that you have already cancelled your pre-auth. If you will not do that, the tax department will continue taking your money, and then it will be very hard to get that money back from the from the seller, because sometimes seller have in contact with their lawyer, sometimes they don't, and in that case you will lose your money. And the same thing will be happening from the seller's point of view. The seller should disconnect. Actually, the same thing happening from the buyer's point of view. If the buyer after the closing, the buyer should inform to the tax department that you are the new owner, and set up with them how you want to pay your property taxes. Sometimes your mortgage broker, your mortgage company, they take care of your property taxes, and they start paying their property taxes from your monthly payment, because they are collecting their property taxes. If they are not collecting their property taxes, it's your responsibility as a buyer to contact the tax department and set up your payment plan with the tax department. If you will not do that, of course they will start charging you penalty on the non-payment of the property taxes, and you will be responsible for taxes. Likewise, this is for the another aspect of home insurance. If you have a home insurance, that's again your responsibility as a buyer to arrange your own home insurance, because the seller will call to their home insurance that please cancel their home insurance effective from the date of closing. And if you don't have a home insurance, and for God forbid any accident or some mishap happened on the property, it will be your responsibility to pay the cost or to clean that mess. So likewise, if you are buying or selling a condominium corporation, again that's your responsibility as a buyer. That's your responsibility to contact with the condo corporation and set up your monthly payment of the condo fee, because the condo fee is your responsibility from the date of closing. If you are buying a house in the middle of the month, 99.9% the seller already paid that month, and you will have at least sometime at the end of the month to set up the payment of common expenses, because the seller will request the condo corporation stop charging them the condo fee, because they are no more the owner of the house. And if you will fail to set up this one, they will have the right to put a lien on your house. If they put a lien on your house, of course this is an extra charge for the lien. So these are the very small things when you are dealing with the real estate property, but sometimes these are very, very important, and sometimes they create a mess for the buyer or seller. Yes, one more thing before I go about the hot water tank. Nowadays hot water tank is becoming very problematic issue for us as a lawyer. So if you are buying a house and there's a part of your agreement that you will assume the hot water tank or any other appliances which are part of the deal, maybe chattels or appliances, something for example, sometimes the seller have a contract with the furnace companies, air conditioning company. So if you are assuming those things, you being a buyer has the obligation to call them and start paying the amount from the date of closing. So if you will note that, again they will start accumulating the funds and they will start charging interest on this amount. I hope you learn a lot from this small clip, and you will take care of those things while you are buying or selling a property. If you have any question, if you need some more information or detailed information about those things, you can always contact our office at adillaw.ca, or you can call us at 905-502-7474. Thank you for watching, and see you next week, same time with a new interesting topic. Until then, take care of yourself and goodbye.